In this short video, which has been recorded on the 21st of January 2021, I'm going to be talking about the Brexit employment implications for employers. The main things that employers need to note is that all existing EU law and EU-derived rights that existed prior to the 1st of January this year have been adopted and remain in UK law. So they remain retained, so there won't be any wholesale major changes for the time being. So employment law, as it was at the end of 2020, will be preserved, and that's in domestic legislation. Any new European Court of Justice decisions that are made after the 1st of January will not be binding on UK courts or tribunals. However, my view is that UK courts and tribunals will continue to look to the EU law and courts in relation to anything that is relevant to UK law, so particularly those types of rights that have come from Europe in the first place that need interpretation and would otherwise have gone to the European Court of Justice for that interpretation. I think the UK courts will continue to look to them and potentially follow those types of decisions, although of course they're not bound to do so anymore. In relation to any potential changes to UK employment law and future amendments that may be made by our government, the trade deal that has been reached does require the UK to balance our employment laws and those of the EU. And what that means is that we need to ensure that there isn't a disparity between the rights and obligations to employees in the UK versus those in the EU that may give companies in the UK an unfair advantage over their European counterparts. If those kinds of things happen and those changes are made, then it may cause the deal in relation to trade to come into question and impact that. So I don't think there are going to be any major changes initially, although there have been reports in the news of some changes being made to some of the less popular types of employment law that have come from Europe. So it's a case of watch this space for any changes, and there may be some, but we will continue to follow Europe, I'm sure. And of course, as I've talked about before, employment law in the UK does go further than Europe in lots of ways for protections for employees. In relation to immigration and employing EU workers, I just want to remind employers that they have a civil and criminal liability if they fail to check an employee's right to work in the UK. Employers are required to obtain evidence of the right to work from all employees, and that should be retained for future record. It's not sufficient to just take the evidence from somebody who you think is European or from outside of the UK. You need to make sure that you're getting ID from everyone and verifying that right to work. EU citizens who arrive in the UK now will have to meet the new points-based immigration system. And those EU nationals who are currently residing in the UK can apply for settled status, and they must do so by the 30th of June 2021. Until the 30th of June, as an employer, you can accept the passport or national ID card of an individual as their right to work. And from the 1st of July, you will need to have proof from them of their EU settled status, or proof that they have met the requirements of the immigration system and they have the right to work in the UK. If you have any questions about anything covered in this video, or you have any specific questions you want to ask us, we do offer an initial free appointment by telephoning on 01983 897 003. Many thanks for watching.